Kilmar Abrego Garcia has never been charged with any crime. He's never been tried or convicted in a criminal court. No immigration court has ever ordered his removal. But on March 12th, ICE agents pulled him over, threatened to take away his son, and sent him to rot in El Salvador's notorious torture prison. The administration has admitted that his removal and rendition was an administrative error. The Supreme Court ordered Trump to facilitate his release, but President Trump and El Salvador have announced that they will not release Mr. Abrego Garcia.
How can I return him to the United States? Like I smuggled him?
This decision arguably defies a Supreme Court order, openly flouts district court orders, and tramples on the fundamental right to due process. Now, we've talked a lot about due process lately because there's been a lot to talk about on the subject, but also because due process is an essential component of a fair and functioning country. Due process rights protect us all against arbitrary abusive actions by the government. They ensure that everyone has the right to counsel, the right to a fair hearing, and the right to hear evidence against them, and the right to rebut that evidence. These substantive rights and processes help to ensure that innocent people aren't punished based on weak or non-existent evidence, that they aren't sent to prison because they don't have the legal knowledge to defend themselves without the help of an attorney, and that they understand what they are being accused of and have an opportunity to present evidence and defenses. But the ramifications of what has happened to Kilmar Abrego Garcia should disturb every American, because if the administration gets its way, then anyone, including the people watching this video, yes, you, the person watching this video right now, could be renditioned to a foreign country as long as the government renditions you fast enough before the courts can kick in. Now, Mr. Abrego Garcia grew up in Los Nogales, El Salvador, where his family ran a pupuseria out of their home. And according to findings by an immigration court judge, David Jones, for years the Barrio 18 gang extorted and threatened the family. The gang regularly threatened to kill him and his brother and rape his sisters if his parents did not pay regular bribes. One day when Mr. Abrego Garcia was around 12 years old, Barrio 18 gang members arrived at the home and told his mother that they were going to take Kilmar and force him to join the gang because his family had not paid the bribe money. Kilmar's father managed to save his son by giving the gang members all the money that they demanded, but the gang continued to stalk Kilmar whenever he left his home. His father, a former police officer, paid them off, but the threats persisted. The police could not help. The gang infiltrated the police. After repeated moves and increasing danger, Kilmar's family sent him to live with his U.S. citizen brother in Maryland. In Maryland, Kilmar apparently lived quietly, working construction and raising a family with his partner Jennifer, a U.S. citizen. In 2019, while seeking day labor at a Home Depot, he was arrested with 3 other men despite no charges or known gang ties. The only evidence offered by ICE was a bull's hat and a claim by a confidential informant linking him to a New York-based gang he had no ties to. Local police had no record of any charges against him. Mr. Abrego Garcia applied for release on bond, and ICE opposed his release, claiming that he was a dangerous gang member based only on the Chicago Bulls hat and hoodie, as well as the confusing confidential informant testimony. And on the basis of ICE's claims, out of an abundance of caution, the immigration court denied Mr. Abrego Garcia's request for release on bond. So he continued to remain in the detention center. From there, he filed an application for asylum with an application for withholding of removal. Now, as stated by the UN, asylum is a form of protection which allows an individual to remain in the United States instead of being removed, deported to a country where he or she fears persecution or harm. And seeking asylum is legal immigration. Under US law, people who flee their countries because they fear persecution can apply for asylum. They're called asylees. And relevant to Mr. Abrego Garcia's claim of asylum, at the conclusion of the 2-day hearing, the immigration judge found that Mr. Abrego Garcia had, quote, provided credible responses to the questions asked. His testimony was internally consistent, externally consistent with his asylum application, and other documents, and appeared free of embellishment. Judge Jones found that Mr. Abrego Garcia also provided, quote, substantial documentation buttressing his claims. However, the judge denied his asylum petition on a technicality. He had missed the 1-year deadline. Instead, he was granted a withholding of removal under INA Section 241B, which is a protection against deportation to El Salvador due to a clear risk of persecution by Barrio 18. Now, withholding of removal offers less protection than asylum. Unlike asylum, it doesn't grant legal status or a path to citizenship. It only bars deportation to a specific country. It's granted if the person proves a clear probability of persecution based on race, religion, nationality, social group, or political opinion, which is actually a higher standard than asylum. Judge Jones found that Mr. Abrego Garcia had met this standard. He had credibly shown that his life had been threatened by Barrio 18 on multiple occasions. And at the conclusion of the hearing, Mr. Abrego Garcia was released to return to his family in Maryland. Now, neither ICE nor local law enforcement ever made further claims about his membership in any gang. And since then, Kilmar has lived peacefully, supporting his family and caring for his disabled son. He had complied with immigration check-ins and had no legal issues until March 12th of this year, when he was pulled over while driving with his son. Now, on March 12, 2025, after finishing a shift as a sheet metal worker apprentice in Baltimore, Mr. Abrego Garcia picked up his son from his grandmother's home. That's when ICE officers pulled him over. They told him his status had changed and threatened to call Child Protective Services unless his partner, Jennifer Vasquez Sura, arrived within 10 minutes to retrieve their son. Mr. Abrego Garcia was shuffled around to several locations over the next few days. His wife Jennifer spent days trying to locate him, discovering that he'd been transferred between multiple facilities across the country. She repeatedly informed the government that Kilmar had been granted a withholding of removal, but her objections were ignored. So Miss Vasquez Sura had no idea where her husband was until her brother-in-law sent a news report about the people who had been sent to El Salvador's torture prison by President Trump. That article contained a picture of a man who had a tattoo and scars that matched Mr. Abrego Garcia's. More news media photos confirmed that he was indeed being held in El Salvador's terrorism confinement center, despite the fact that he had a valid withholding of removal, and despite the fact that he was never given a hearing or was ever formally charged with any wrongdoing. So now, with that knowledge, Ms. Vasquez Sura filed a suit on behalf of her husband, herself, and their 5-year-old son in the United States District Court for the District of Maryland. Now, in their complaint, the plaintiffs alleged that by sending Mr. Abrego Garcia to the Terrorism Confinement Center, or CCOT, without any kind of hearing, the Trump administration had violated the INA provisions governing withholding of removal orders, the Administrative Procedure Act's prohibition against arbitrary and capricious government actions, and the Fifth Amendment's guarantee of due process. Mr. Abrego Garcia also filed a habeas corpus petition, arguing that the Salvadoran government was detaining him at the express direction of the Trump administration. And if you've been following along with all the Supreme Court antics involving the JGG plaintiffs, previously in Judge Boasberg's courtroom, then you know that a habeas petition was an incredibly important thing for them to file. We'll talk more about that in a second. Now, the Trump administration is paying El Salvador $6 million to house 300 men for a year. Trump and Salvadoran leader Nayib Bukele, the self-proclaimed coolest dictator in the world, have both publicly bragged about this arrangement. In a March 16th post on Twitter, Bukele acknowledged their financial agreement, stating, quote, "Today, the first 238 members of the Venezuelan criminal organization Tren de Aragua arrived in our country. They were immediately transferred to CCOT, the Terrorism Confinement Center, for a period of 1 year, renewable. The United States will pay a very low fee for them, but a high one for us." Bukele also bragged about how the prisoners in CCOT are being used as slave labor, stating, quote, "Over time, these actions combined with the production already being generated by more than 40,000 inmates engaged in various workshops and labor under the Zero Idle List program will help make our prison system self-sustainable." The plaintiffs also allege that the Trump administration knows that the men in CCOT are being subjected to torture. Their complaint includes a harrowing list of details about the conditions in CCOT based on credible news reports and independent investigations, including 153 inmate deaths in a 1-year period, many of which can be attributed to torture, beatings, strangulation, and lack of medical attention. Now, autopsies have revealed patterns of cuts, hematomas, sharp object wounds, and signs of strangulation. Survivors of the prison report being subjected to electrocution and untreated infections. The prison has no windows, fans, or air conditioning despite hot, humid, tropical conditions. And prisoners are housed in overcrowded cells and are denied access to reading materials, familial visits, exercise, and outdoor time. Given the appalling conditions that he's being held in, Mr. Abrego Garcia and his family implored the court to grant a temporary restraining order, or TRO. Plaintiffs noted that if the Trump administration had wanted to remove Kilmar legally, it had several lawful options. It could have appealed the original grant of withholding of removal, sought to reopen the proceedings under the INA, or even deported him to any country other than El Salvador. The only country his withholding protected him from was El Salvador. Instead, the administration pursued an entirely different path. And maybe Mr. Garcia is a member of MS-13. Maybe he's Space Hitler, but we don't know because the administration never tried to prove it. Unlike the JGG plaintiffs, it isn't relying on the Alien Enemies Act in Kilmar's case. That executive order applies only to Venezuelan nationals. Rather, the sole justification the administration has offered is a vague, unsubstantiated claim that Mr. Abrego Garcia was affiliated with MS-13. The State Department had previously designated MS-13 as a major transnational criminal organization designated terrorist group in February of 2025. Now, the Trump administration has presented zero evidence that Mr. Abrego Garcia is a member of MS-13 or any criminal organization. Mr. Abrego Garcia has never been found guilty of any crime or even charged with any crime. But in response to the plaintiff's motion for TRO, the Trump administration actually admitted that, quote, although ICE was aware of his protection from removal to El Salvador, Abrego Garcia was removed to El Salvador because of an administrative error. The government's declaration by Robert Sina, acting field office director for enforcement and removal operations at ICE, affirmed this, stating, quote, through administrative error, Abrego Garcia was removed from the United States to El Salvador. This was an oversight. Now, despite this admission, the administration went on to claim that the Maryland court cannot offer Mr. Abrego Garcia any relief. The administration argued that Mr. Abrego Garcia's case must be brought as a habeas corpus claim, which can only be heard by a court with jurisdiction over the detainee's custodian. And they argued that since he was already deported to El Salvador when the suit was filed, no U.S. court has jurisdiction. The Trump administration also asserted that the plaintiffs lack standing because the court can't compel El Salvador to act. Now, Maryland Federal District Judge Paula Zenas was understandably skeptical of all the administration's claims. She rejected the administration's evidence-less claims that Mr. Abrego Garcia is an MS-13 gang member, stating, quote, "When someone is accused of membership in such a violent and predatory organization, it comes in the form of an indictment, complaint, or criminal proceeding that has a robust process." And at the hearing, she said, quote, "All this points to a functional control, and that if the United States as a contracted party can have the functional control of the placement, the wrongful placement, they certainly have the functional control of the return." So on April 4th, the judge granted a preliminary injunction ordering the Trump administration to, quote, "facilitate and effectuate the return of plaintiff Kilmar Armando Abrego Garcia to the United States by no later than 11:59 p.m. on Monday, April 7, 2025. White House Deputy Chief of Staff Stephen Miller responded to the news about Judge Zenas' ruling on Twitter saying, quote, "Marxist judge now thinks she's president of El Salvador." Bukele posted on Twitter with his usual level of gravitas and maturity, and White House Press Secretary Caroline Leavitt issued a statement that, quote, "We suggest the judge contact President Bukele because we are unaware of the judge having jurisdiction or authority over the country of El Salvador." And so the administration immediately and predictably appealed Judge Zenas' order, begging the Court of Appeals of the Fourth Circuit to please allow them to send people to the gulag immediately with no questions asked. And predictably, all three judges in the Court of Appeals were unconvinced by the administration's arguments. Judge Thacker, an Obama appointee, wrote the opinion of the court saying that, quote, "The United States government has no legal authority to snatch a person who is lawfully present in the United States off the street and remove him from the country without due process. The government's contention otherwise and its argument that the federal courts are powerless to intervene are unconscionable." She also noted the government, quote, "screwed up and must, quote, clean up the mess it has made." And so the Trump administration asked the Supreme Court to vacate the district court's ruling. And on April 7th, the Supreme Court granted a temporary stay, pausing Mr. Abrego Garcia's return while it considered whether Judge Zenas' order should be vacated. The court allowed the district court's temporary restraining order to expire, which is how the Trump administration got out of the whole JGG debacle where Judge Boasberg had ordered them to turn the planes around, which is not a great pattern. And finally, on April 10th, the Supreme Court unanimously ruled against the Trump administration's motion to vacate Judge Zenas' order. And this decision by the Supreme Court is a complete mixed bag. But all 9 justices, including 6 Republican appointees, 3 of whom were appointed by Trump, found that the lower court's order to facilitate the return of Mr. Abrego Garcia should stand. The justices found, though, that the portion of the order that commanded the Trump administration to actually effectuate Mr. Abrego Garcia's return may have exceeded Judge Zenas' authority and would need to be clarified by Judge Zenas with, quote, "due regard for the deference owed to the executive branch in the conduct of foreign affairs." Now, the Supreme Court indicated that Judge Zenas' order that the government effectuate Mr. Abrego Garcia's return might exceed judicial authority. The court didn't spell out a specific reason for that, but a typical reading of the term effectuate would indicate that it would require the government to ensure a particular outcome, as opposed to requiring the government to simply take steps to facilitate an outcome. And there are reasonable separation of powers issues here. Ordering the administration to guarantee Mr. Abrego Garcia's return could mean effectively ordering some kind of military action if El Salvador outright refuses to return him. And everyone agrees that a judge can't do that. Now, facilitate is a much looser term, which has led to a series of disputes in this case since the Supreme Court's holding. The Trump administration is reading the order to facilitate Mr. Abrego Garcia's release from the Salvadoran custody in the most minimal fashion possible, claiming that when Judge Zenas and the Supreme Court ordered this, all they really meant was removing any domestic obstacles that would otherwise impede the alien's ability to return. And the Supreme Court also instructed the government to, quote, "be prepared to share what it can concerning the steps it has taken and the prospect of further steps." But Justices Sotomayor, Kagan, and Jackson took the Trump administration to task for its illegal action, stating that, quote, "to this day, the government has cited no basis in law for Abrego Garcia's warrantless arrest, his removal to El Salvador, or his confinement in a Salvadoran prison, nor could it." And the 3 justices raised alarms about the Trump administration's due process violations, warning that, quote, "the government's argument, moreover, implies that it could deport and incarcerate any person, including U.S. citizens, without legal consequence so long as it does so before a court can intervene." The concurring justices admonished the administration to comply with due process of law and provide Mr. Abrego Garcia with all the process he should have been entitled to, including notice and a hearing. But the Supreme Court's ruling also opened the door for Trump to argue that he has no power to actually effectuate Mr. Abrego Garcia's release. Now, unless you're the US government, if you're kidnapping immigrants, you're going to want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying that your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. On remand, Judge Zinnes quickly amended her order to remove the word effectuate. She commanded the Trump administration to provide the basic details about Mr. Abrego Garcia's whereabouts and status, as well as the steps that the government is taking to recover him, in keeping with the Supreme Court's order that the government, quote, should be prepared to share what it can concerning the steps it has taken and the prospect of further steps. And she gave the administration until 9:30 a.m. the following morning to provide her the relevant details. After they failed to meet this deadline, Judge Zinnes granted the Trump administration an extension until 11:30 a.m. that day, a deadline that they once again failed to meet. But instead of providing the required answers, the Trump administration filed a motion whining about the impossible deadline and claiming that they simply could not share any of the requested information with the court at this time. But Judge Zinnes wasn't having it and ordered the Trump administration to respond daily with the following information, quote, the current physical location and custodial status of Abrego Garcia, what steps, if any, defendants have taken to facilitate his immediate return to the United States, what additional steps the defendants will take and when to facilitate his return. She scheduled a follow-up hearing for Tuesday, April 15th. Now, the government's first status update was a 3-paragraph insult, and the only actual information contained within it was that Mr. Abrego Garcia was alive and imprisoned at CCOT. One wonky thing is that when you file a status report like this, it must be backed up by a declaration, which is a written statement that's made under oath. This particular statement is about as wishy-washy as you can get. It was filed by a member of the Department of State, and it says, quote, it is my understanding based on official reporting from our embassy in San Salvador that Abrego Garcia is currently being held in the Terrorism Confinement Center in El Salvador. He's alive and secure in that facility. He is detained pursuant to the Sovereign Domestic Authority of El Salvador. Now, to me, as a litigator, given the several layers of intermediation before that person actually signed their name to something under oath, that sounds like someone who doesn't want to be held in contempt for actually making factual statements that may or may not be true. But notwithstanding, the next status update was even less substantive. The government representative simply stated, quote, it is my understanding that the defendants have no updates for the court beyond what was provided yesterday. Again, this means the administration is simply deciding not to answer the court's questions, or that is simply not taking steps to facilitate Abrego Garcia's return. Now, in light of this non-compliance, plaintiffs filed a motion with the court requesting additional relief, including expedited discovery against the Trump administration and a potential contempt finding against the administration. The Trump administration responded, claiming that when the Supreme Court and Judge Zinnes directed them to facilitate Mr. Abrego Garcia's return, all that really meant was that they should, quote, take all available steps to remove any domestic obstacles that would otherwise impede the alien's ability to return here. But as luck would have it, because we live in the worst timeline and everything is kayfabe, on April 14th, Trump and Bukele actually had a televised meeting at the White House where they mocked the court system. On the same day, Stephen Miller claimed that Abrego Garcia was not sent to El Salvador by mistake.
He was not mistakenly sent to El Salvador.
Okay, so do you still
He's
believe
an illegal
he is a
alien
member of
from
MS?
El Salvador?
But as we've talked about, it's important to note that the administration has admitted their mistake to the court at least 3 times. First by Robert Sina, acting field office director for enforcement and removal operations at ICE, and twice in briefs filed by the Solicitor General, D. John Sauer. Attorney General Pam Bondi has also falsely claimed that 2 courts ruled that Mr. Abrego Garcia was a member of MS-13.
He was illegally in our country. He had been illegally in our country. And in 2019, 2 courts, an immigration court and an appellate immigration court, ruled that he was a member of MS-13 and he was illegally in our country.
And Bukele even labeled him a terrorist, but no court has ever concluded that Mr. Abrego Garcia is a terrorist or a member of MS-13. And as we talked about, a court issued the withholding of removal the last time Abrego Garcia had been in court because he had in fact been a victim of gangs in El Salvador. But according to the Attorney General, what the Supreme Court meant when they said that the government has to facilitate Mr. Abrego Garcia's return is just that if President Bukele decides to return him, the United States has to, quote, provide a plane.
This is international matters, foreign affairs. If they wanted to return him, we would facilitate it, meaning provide a plane.
Now, in the same meeting, President Bukele confirmed that he has no intention of returning Mr. Abrego Garcia to the United States or releasing him within El Salvador.
How can I return him to the United States? Like I smuggle him into the United States, or what do I do? Of course, I'm not going to do it.
And to add injury to the insult to the injury, Trump says he really does want to send American citizens to the terrorism prison in El Salvador.
I said, homegrowns are next. The homegrowns. You got to build about 5 more places.
Yeah, that's fair.
All right.
So we are not in a good spot. In this case, the government has told 3 courts that Kilmar Abrego Garcia was wrongfully removed, and a unanimous Supreme Court said that the government must facilitate his release. And yet, Trump is now openly flouting the court's order in order to keep an innocent man imprisoned. The ramifications here could not be more dire. Trump asserted that he has a right to do this to American citizens, telling Bukele that he should build 5 more prison camps that Trump will fill with undesirables. which is plainly at odds with the claim that they have no power to get Mr. Abrego Garcia back, which was foreshadowed in Justice Sotomayor's dissenting opinion in JGG versus Trump, where she said, quote, "What if the government later determines that it sent one of the detainees to CCOT in error, or a court eventually decides that the president lacked authority under the Alien Enemies Act to declare that Tren de Aragua is perpetrating or attempting an invasion against the territory of the United States? The government takes the position that even when it makes a mistake, it cannot retrieve individuals from the Salvadoran prisons to which it has sent them. The implication of the government's position is that not only non-citizens, but also United States citizens could be taken off the streets, forced onto planes, and confined to foreign prisons with no opportunity for redress if judicial review is denied unlawfully before removal. At base, the Supreme Court unanimously affirmed the district court's order, quote, properly requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. And back at the district court, the government's final status report included no new information about Mr. Abrego Garcia's status. The government submitted a declaration by DHS Acting General Counsel Joseph Mazzara, who said that the U.S. was prepared to facilitate his entry into the U.S. by not allowing him to re-enter the United States. If Mr. Abrego Garcia presents to a port of entry, the United States will, quote, remove him to a third country or terminate his withholding of removal because of his membership in MS-13. Again, no mention of the regular immigration process. The Supreme Court has yet to say what facilitate means in this context, but the government is stating for the record that it believes it can send Mr. Abrego Garcia somewhere without any due process, and that's within the meaning of the word facilitate. Now, you might be wondering whether the government can get away with that without being held in contempt of court, and so am I. And in another contentious hearing before Judge Zenas on April 15th, the administration tried to argue that it had taken steps to fulfill the court's order to facilitate Mr. Abrego Garcia's return. The only evidence that the administration could offer, though, was the White House meeting with President Bukele the day before, which Judge Zenas found wholly insufficient. The government apparently showed up with a transcript of the meeting and asked for it to be considered evidence that the government was up against a foe that was impossible to defeat, Trump's pal Bukele. But Judge Zenas was not amused. She said she would not accept an out-of-court transcript of a YouTube video as evidence, and instead she would build a record using the rules of evidence. You know, the way we've done this for hundreds of years. And Mr. Abrego Garcia's counsel argued that the government has done nothing to facilitate his release and asked for the deposition testimony of someone with authority to explain what actions the government has taken to comply with the Supreme Court's order. And in response to the administration's recalcitrance, Judge Zenas left open the possibility of a contempt finding and granted the plaintiff's request for expedited discovery. She indicated that she would be reviewing the government's discovery response to evaluate whether or not the administration is in compliance with her order. She told the government's lawyers to cancel your vacations because she intended to do this on a very tight 2-week timeline. Now, that may not sound like a tight timeline to non-lawyers, but it is extremely fast for a case of this magnitude. The government's lawyer, Drew Ensign, stopped short of saying that the government would comply with the court's discovery orders. He indicated that he would probably object on the grounds that attorney-client privilege applied, and therefore someone like Mr. Mazzara could not be expected to testify. And Ensign repeatedly told the court that there was no factual issue here, and according to Anna Bauer, who was in the courtroom, Judge Zenas wasn't having it. She said, quote, to what SCOTUS said was squarely in my power, and in my view, you have not fulfilled the mandate I've issued. Discovery will bear that out because the affidavits are insufficient. Then you may see the government try to appeal the court's discovery order. Ensign argued that Judge Zenas first needed to clarify her TRO, and the judge said no additional order was necessary. And as Bauer reported, paraphrasing, quote, not that difficult, the Supreme Court has spoken. Let's talk about what the Supreme Court has unequivocally deemed to be lawful. You made your arguments there, and this is now about the scope of the remedy. And Judge Zenas' order following the hearing addressed the dispute over the meaning of the word facilitate. And she points out, quote, Merriam-Webster defines the term as to make it easier or less difficult to free from difficulty or impediment, whereas the Oxford English Dictionary defines facilitate as, quote, to assist a person to enable or allow a person to do something, achieve a particular result. And the judge wrote that the defendants know what the word means and they failed to live up to any of these definitions. Quote, the defendants therefore remain obligated at a minimum to take steps available to them toward aiding, assisting, or making easier Abrego Garcia's release from custody in El Salvador and resuming his status quo ante. But the record reflects that the defendants have done nothing at all. Instead, the defendants obliquely suggest that facilitate is limited to taking all available steps to remove any domestic obstacles that would otherwise impede the alien's ability to return here. The fallacy in defendants' argument is twofold. First, in the immigration context, as it were, facilitating return of those wrongly deported can and has included more extensive government efforts endorsed in prior precedent in DHS publications. Thus, the court cannot credit that facilitating the ordered relief is as limited as defendants suggest. Second, and more fundamentally, defendants appear to have done nothing to aid in Abrego Garcia's release from custody and return to the United States to ensure that his case is handled as it would have been but for defendants' wrongful expulsion of him. Thus, defendants' attempt to skirt this issue by redefining facilitate runs contrary to law and logic. And in a footnote, the judge references the other part of the Supreme Court's order, which says the district court must still give due regard for the deference owed to the executive branch. But in this instance, Judge Zenas says, quote, deference does not mean the court must ignore the defendant's repeated refusal to provide even the most basic information as to any steps they have taken to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. But first things first, the plaintiffs will be allowed to conduct expedited discovery. And remember, we talked about the government declarations and not wanting to get subjected to contempt or discovery? Well, Judge Zenas is all over that. According to Anna Bauer, during the discussion about discovery, the judge said depositions will be completed by Wednesday, April 23rd, any impedient. The government lawyer Ensign said, quote, we understand court's position. The judge said, so that means no impediments? Ensign says, we don't know at this time who will be deposed. Zenas says, no, I'm saying the people who you've put forward as affiants. Ensign says, I'm not prepared to put forward objections at this time. One of the affiants is acting general counsel. To which the judge says, you should have considered privilege when you put them up as an affiant, but if you have privilege objections, you can get them to me. In other words, the government made lawyers sign factual sworn statements for which they may or may not have personal knowledge. And if you have someone sign a declaration under oath, the court is allowed to test the veracity of those statements, and you've arguably waived privilege. Unlike, for example, when a lawyer has signed a brief, which isn't under oath, though it does have its own obligations. So Judge Zenas is signaling that she is not going to put up with objections to that discovery. And in fact, in the judge's order, she specifically calls out the 4 government affiants and says that the plaintiffs can depose them. And those depositions must be completed by April 23rd. Fun. Now, after that contentious hearing, lawyer Heidi Feldman noticed that the court is following the exact same procedure that was used in Cabell versus Babbitt. In that case, the court found that the Department of the Interior had grossly mismanaged native trust funds and then failed to comply with prior court orders, actively misled the court, and even provided false information. This conduct implicated Treasury Secretary Robert Rubin and Interior Secretary Bruce Babbitt. The court issued an order to show cause why the government should not be held in contempt, and then held hearings to evaluate the evidence and hear testimony. And we talked about the standard of civil contempt in the video about Trump violating court orders. And in civil contempt, the aim is to typically force the contemner to comply with the court's directives. In the Cabell case, the court first had to consider whether the orders were clear and reasonably specific, and the government tried to argue, just as Ensign did here, that there was too much ambiguity for the government to understand how to comply. The court must then be persuaded by clear and convincing evidence that the contemner actually failed to comply. And importantly, you don't have to prove that the contemner intended to disobey the order. The focus is simply on whether they failed to meet the terms of the order. And in Cabell, the government didn't produce the required records, failed to implement accounting standards, and then failed to communicate transparently and in good faith with the court. Which is why several times during the April 15th hearing, Judge Zenas warned the government that it needed to communicate with her in good faith. And in Cabell, both cabinet secretaries had to appear in court, and both were found in civil contempt. And the remedies included appointment of a special master to monitor compliance and independently review the agency's behavior, court supervision over native trusts, and a warning that future noncompliance would result in sanctions. So the bottom line here is that the Supreme Court approved most of what the judge ordered and cut it back based on what the court can and cannot do. The government is currently misrepresenting what the Supreme Court said and is so far refusing to do what the court has required. Judge Zenas is moving forward and she is pissed, and she's laying out the framework, like Judge Boasberg before her, to make life very difficult for the government. And we'll see who blinks first. But it's particularly interesting to look at the media's response to the Supreme Court's order to facilitate the return of Kilmar Abrego Garcia. About 450 sources covered the story, with only about 10% coming from the right, 60% coming from the center, and 30% coming from the left. And when you examine the headlines, you see some very different frames emerge that shape how readers interpret and understand the Supreme Court's ruling. Headlines from the right are the most likely to put the word facilitate in quotes, which implies room for the Trump administration to interpret what actions constitute facilitating Garcia's return. But from the center, we see headlines like these that use the phrase must work to bring back instead, while also being more likely to use the language describing Garcia as wrongfully deported. And then from the left, headlines typically frame the court's ruling in stronger language, such as ordering the return of Garcia and overruling the Trump administration. Now, the headlines that you read first have immense power to shape how you understand the news, and that's why I like to see the news from as many angles as I can with the help of today's sponsor, Ground News. Ground News is a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. And right now they're offering LegalEagle viewers 40% off their unlimited access Vantage subscription. You can scan the QR code or use the link in the description to get a discount for a limited time. Because Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. One of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. This can be especially helpful when reading stories from sources you've never heard of, where there's no telling who owns it or what agenda they might have. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum. Like this related story of journalists at 60 Minutes discovering that 75% of the 200 Venezuelan immigrants recently renditioned to the El Salvadoran Gulag had no criminal record in the United States. This story was entirely ignored by the right-leaning sources, with the vast majority of sources coming from the left and center. And this type of analysis helps explain why we often talk past each other and why some people seem hyper-focused on what seems like nonsense or fake news. But all this is why Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off the Ground News Vantage subscription by scanning the code on screen or clicking on the link down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and Blind Spot feed. And by subscribing, you'll support an independent news platform working to make the media landscape even more transparent. So click the link below or scan the code today. And after that, click on this link over here from where LegalEagle, or I'll see you in court.